Hello everyone, and thank you for joining us for today's presentation as part of the Industry Insight webinar series. The topic this time is building mobile solutions into your practice. Speaking today will be Joshua Lennon of Clio. Joshua is an attorney admitted to the New York Bar. He studied law at St. Louis University School of Law, obtaining a Juris Doctorate and a certificate in international and comparative law. During this time, Joshua clerked for the Missouri Attorney General, helping prosecute discrimination claims on behalf of Missouri citizens. He also studied European Union law at the University of Georgia School of Law's Brussels Legal Seminar. When working for Thomson Reuters' publishing department in both the U.S. and Canada, he helped legal practitioners improve their services. Joshua currently serves as lawyer in residence for Clio, providing legal scholarships and research skills to the leading cloud-based practice management platform headquartered in Vancouver, Canada. He's been a guest lecturer for movements like legal hacking and legal technology at schools like MIT, Suffolk Law, and Vanderbilt. He's also spoken before organizations like Reinvent Law and the ABA Law Practice Futures Initiative. The presentation today will be followed by a Q&A. Please enter your questions into the question box in the webinar panel on the right side of your screen. All questions will be addressed at the end of the presentation. We're recording the webinar and we'll be sending the video in a follow-up email in a few days. We'll also post the video on our blog over at lawtechnologytoday.org. Again, that's lawtechnologytoday.org. Thank you all for joining us, and we'll now begin the webinar.
Thanks, Austin. Hi, everybody. I'm Joshua Lennon. I'm the lawyer in residence at Clio. That is my actual title. I'm an attorney, as he said, admitted into New York, and you can always connect with me on Twitter at Joshua Lennon. So I do want to go over the agenda for today. I want to talk about why you want to go mobile, ethics when accessing client data in public, setting up your mobile devices for secure access, and some apps to choose for legal practice. And as Austin said, we'll address your questions at the end, but please feel free to type them in at any time. So let's jump to the first topic, why go mobile? And I think the most important thing that most people don't realize is that going mobile isn't about working longer or even harder. It's actually about having flexibility. So in a study that was done in 2014, we found that at least 70% of employees would quit their current job in order to take up a job that had more flexible work arrangements. And what did they value? They valued the idea of having remote access and also flexible hours. They wanted to be able to work from different locations as was convenient for them and be able to take some of the busy work and maybe move it to times when they weren't busy. And so when asked in this continuing study how would they go about doing that, what they were looking for was the ability to access email on the go, the ability to use cloud apps on the go, and a few said that they could use a remote desktop, but it was not their preferred option. And the reason they wanted to use these types of tools was that they could keep more personal and social commitments. And they said that they could do this if they had flexible and remote options because they can work anytime, anywhere they want. Now what's interesting to me is we know that lawyers work outside of their office all the time. The ABA, LTRC, actually puts out an annual legal technology report. And one of the things they survey you guys on is that they ask, do you access the internet for law-related tasks away from your primary workplace? So your office, if you work in an office, your home office or co-working location, if you work in any of those, and 77% of you said that you regularly access the internet for law-related tasks when you're on the go. And the ABA even breaks that down into quite a bit of detail. So for example, we know that 77% of you regularly access it for law-related tasks when you're at home, but still a sizable percentage of lawyers access law-related tasks, whether they're in transit, whether they're at the courthouse, even when you're at opposing or co-counsel's office, you're occasionally using these tools. What's interesting to me from further diving into that study is that you're probably using your mobile device as a phone, which is actually somewhat contrary to how a large percentage of the population is using their mobile device anymore. People don't like to spend time on the phone, but they do like to spend time on the mini computer they have in their pocket. So if we take a look, we find that most lawyers, according to the ABA, use the telephone or email the most on their mobile device. And only once we get all the way down do we see that people are starting to use other different types of services on their mobile device. And when we get to, I think, legal-specific smartphone uses, things like using a mobile-specific research app, accessing the database that holds your case files, tracking time and billing, we see that very few of you actually use your smartphone for things that are related to the practice of law. You're not benefiting and setting yourselves up for that kind of flexibility that you could have if you added mobile technologies into your practice of law. And we can back that up again with studies from the ABA, which found that just around 40% of respondents report that you have downloaded a legal-specific app to your smartphone. And part of that could be that there aren't as large a volume of legal apps out there as there are regular apps, but I do think we should be taking a look at some specific ethics around apps that you're using and whether or not you're using the right apps as a part of your mobile technology. And that leads us to our next topic, ethics when accessing client data in public. So believe it or not, there are actually ethics opinions on using mobile phones as a part of legal practice. Unfortunately, most of them came out right around 1994 when mobile phones started taking off. These are the brick phones that people had inside of their cars. They were almost physically attached to the cars, but were rapidly getting smaller. And so several bar associations took a look at the technology and started providing ethical opinions. So here's one from the New York City Bar back in 1994 that tells us that a lawyer should exercise caution when engaging in conversations containing or concerning client confidences or secrets by cellular or cordless phones, which was interesting. They were worried about radio waves being intercepted, and that lawyers should consider taking steps sufficient to ensure the security of such conversations. And while you may think that an ethics opinion from 1994 is horribly dated, I actually think we've circled back around to where this particular opinion applies in our everyday practice. So we know there are a couple of ethics rules and duties that apply to practicing mobilely, and that you should keep in mind as a part of it. So if we look at the model rules of professional conduct, and these are the rules put out by the ABA and adopted by virtually every jurisdiction out there, almost verbatim, except for California, who has analogous systems. So if we look at Rule 1.4, we see actually there are some really interesting duties that you are ethically compelled to do, such as keeping your client reasonably informed and promptly complying with reasonable requests for information. Now, promptly complying is definitely a changing metric nowadays. With the rise of internet technology, with the rise of 24/7 access to information, with the rise of outsourced customer service, taking advantage of a global environment, we've actually trained most customers out there to expect immediate service, especially online. Now when it comes to clients, as opposed to just regular consumer customers, we have to both create an expectation of what is reasonable in terms of contact and response for lawyers, but as comment 7 from Rule 1.4 says, we can't withhold information just to serve our own interest or convenience. So just because a client is calling us in panic at 5:30 at night and our office closes at 5 doesn't mean we can necessarily just ignore the phone call. We actually instead have to make sure we're taking reasonable steps to promptly comply. Now, what are some things you have to worry about with that when it comes to mobile? Well, you do have to worry, for example, about a loss of a device and whether that will prevent you from promptly complying. We know that 1/3 of robberies involve the theft of a mobile phone. We know that hundreds of thousands of mobile phones are reported lost every year. And we know that accidental damage to a mobile phone is 10 times more common than a loss or a theft. So if you're relying upon a mobile device as part of your practice, you also have to worry about the integrity and accessibility of that device. So at some point, you just have to assume that your device is going to be lost, broken, or inaccessible, like you leave it in the back of a taxi. And you need to plan on this being the case when it comes to using a mobile device in your practice. So what are some things that you can do to really help with that? One is back up your device frequently. I recommend on a weekly basis in order to make sure that if you accidentally drop your phone, if you accidentally leave it on the subway or in a taxi, that you can immediately download that backup, install it onto a new phone, and be operational almost instantaneously. I also recommend that you put in certain security protocols, like the ability to find and wipe your phone if you're lost. One example of that is the Find My Mobile Phone app for iPhones, which you should have turned on. And it gives you the ability to both find your phone in case you've lost it and lock it in case somebody else has access to it. And that leads us to the next duty, and that is confidentiality. Rule 1.6 tells us that a lawyer shall not reveal information representing to the representation of a client, and under point C, shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure. And if you take a look at the comments, they do talk about security, all right? And under comment 19, they say that this duty does not require the lawyer to use special security measures if the method of communication affords a reasonable expectation of privacy. So if you've got a mobile phone, you should have certain types of security that are reasonable for you to use, and you have a reasonable expectation of privacy. Now we're going to take a look at what some of those are, but you do need to know that what is reasonable is changing as these mobile phones advance. So there are some consequences that you have to worry about when it comes to ethics for a mobile practice, and that is the unauthorized access to client information by a third party and the inability to act with diligence and promptness on behalf of them. So how do you take care of this? One, take reasonable efforts, and I'm going to show you that in our next step, on how to prevent access to client data via your mobile device. This doesn't mean that you can't use mobile computing, but you should lock it down in a way that makes it difficult for people to access that data. And you should also, again, have the ability to act promptly and with diligence. And that, I think, is having a good backup. So if you have both of these things in mind, you should be able to integrate any mobile technology into your practice quickly and easily. So let's talk about securing that mobile device. And I think there are 8 steps that you need to take advantage of. So the first is choosing services with mobile components so that they integrate across devices. Set a bring your own device policy for your law firm. And that's actually incredibly important as more and more people bring their personal devices and expect to be able to access things like email via their mobile devices. Protect them, use secure connections. There's a whole bunch of common sense that comes into it, but I do think going beyond common sense is there's now a class of tools that enable you to force security upon your law firm staff, update frequently, and back up even more frequently. So why do you want mobile services? So what we're finding is that in a recent survey, 61% of businesses had employees who created a mobile app for use at the office. And this is important. They created the app without any input, help, or even awareness of their IT department. What does that look like? Well, we're seeing that a lot of web services are starting to become mobile friendly. So say you have a client intake checklist that you've relied upon for over a decade. What's happening is your employees, your legal secretaries, your paralegals, are swinging by Google Apps for Business, or G Suite as they call it right now, taking that checklist, creating a digital form in a spreadsheet, and then handing that digital form over to the client to fill out. Now, that is actually a great tool. It actually makes it much more convenient for your client to provide information. The danger is you don't know that they've signed up for a service and that that service may be storing information in a way that is not compatible with your professional duties. So to cut this off, you need to make sure that you're picking services that already have a mobile component in them, such that your staff are much more willing to use the tools that you provide and less likely to create shadow IT. So you're going to pick tools that are easy to use, that people like, but are also secure, and that is how you protect your law firm. You also protect your law firm by having a bring your own device policy. And we know this isn't as common as we would like in law firms. Again, jumping back to the ABA's legal technology report, we see that when it comes to bring your own devices, not even half of most law firms actually have policies setting this. So we see for solos, lawyers at 2 to 9, and lawyers of 10 to 49 that you may be able to bring a tool like this, but they don't really have a policy on how to secure it. So I think it's important that you start providing firm-specific mobile services that can be used across mobile devices that enable remote wiping of those devices if someone ever leaves the firm and takes their personal device with them. And you should also require that if they're going to access information on a personal device, that you can encrypt that device. Now I want to show you some examples of this. So this is part of protecting devices. And these are two services built into Mac and PC computers right off the bat. So on the left we see Mac. You can just turn on the file vault right here and it automatically starts encrypting the hard drive. And for Windows, it's called BitLocker Drive Encryption. I believe this is part of the Windows Pro series, so you should be using Windows Pro rather than Windows Home. And it will turn on, again, an encryption of the hard drive. And so if someone does not have a password to log into that laptop, they can't access the files. This is incredibly important. You should just turn these on by default. It's literally a mouse click at this point. How reasonable is it that you don't secure a device that travels and contains potentially sensitive client information? You should, immediately at the end of this broadcast, go to these settings and turn them on right now. If nothing else, you're much better off. We're starting to see that iPhones are encrypting themselves by default, but Android, you may have to turn that on, especially on the older phones. And so if you lock down the device itself, you should also be locking down the connection. So we know that 40% of lawyers admit to using public Wi-Fi, so Wi-Fi at a coffee shop, Wi-Fi at the airport, but only 23% of them are necessarily focusing on secure socket layer encryption on that connection. So what is SSL encryption? For most people, it's actually this little green lock on the bar of your web browser. If you see that, you know that you are actually using an encrypted connection to talk to the computer on the other side of the internet. And any data passed back and forth is difficult or next to impossible for someone to intercept and read. And this is in line with what we think are some emerging ethics opinions on the requirement of encryption as a part of the practice of law. So California has a formal ethics opinion that came out in 2010. It's number 179 that suggests that encrypting email may be a reasonable step when the circumstances call for it, particularly if the information at issue is highly sensitive and the use of encryption is not onerous. So what does that mean for you? It means that you should be using web services and communication tools that have encryption built in. Now, the majority of legitimate website services will force a secure connection. If you go to Clio.com, for example, we will automatically request a secure connection between you. Before you even log in, before you provide a username and password, we're already encrypting that information that passes back and forth between us. So picking the right services will overcome this woeful deficit of using encryption on connections, but you should be aware of it and be looking for this type of green lock and this phrase, HTTPS, in all of the websites where you store or pass sensitive information. And trust me, once you start looking for it, you'll see it in a lot of places. Now, is that enough to prevent your information while you or your employees are out and about? Maybe not. So it also requires some common sense. This is an article from 2009 talking about a conversation that was overheard on a train from Washington, D.C. to New York City. And there was a lawyer who, on his phone, was having a very important conversation about the fact that this firm, Pillsbury, planned to lay off somewhere in the range of 15 to 20 attorneys from 4 offices by the end of March, including a few senior associates and 2 or 3 first-year associates. Now, what was interesting was all throughout this conversation that he was having in public on an enclosed train where everybody could hear him, he kept stressing how important it was to keep this information secret. That's where common sense comes in. You should not be having those types of conversations in public. You should not be entering client information where someone can look over your shoulder. So if you're going to have a mobile practice, definitely make sure you're talking about some simple common sense steps that can be taken to help. Whenever I go to legal conferences, and I go quite frequently, at least once a month, I always see attorneys out in the hallway on their phone having important conversations, and they're not 10 feet away from another batch of lawyers. While it may be difficult and somewhat onerous sometimes to find a quiet private spot in which to have this conversation, that's the type of common sense step you should be taking if you're going to have mobile practice. Now, you don't have to rely just on common sense. You can actually force things to be more secure sometimes. And there are certain things that you can do for that. For example, you can require strong passwords such that if someone loses their laptop or their mobile phone, it's actually very difficult for them to log in. This is an example of a password security requirement from Clio, and you can just turn this on and suddenly all of your clients or all of your staff have to use a strong password. You can see the different requirements for that strong password. You can require two-factor authentication, and this is the second easy thing you can do at the end of today's broadcast to make yourself more secure. And two-factor authentication enables you to require more than just a password. So when I log into Clio, I also have to open a special app on my mobile device that's called Google Two-Factor Authentication, and it sends me a little number code that is only good for about 10 seconds. And if I don't enter that number code, even though I have my username and password, I can't log into Clio. So importantly, this prevents other people who try to guess my password, try to guess my username from other locations from being able to log in. And I use this on everything. I use two-factor authentication on Clio. I use it on my email service. I use it on my online file service. I even use it on my social media, making it hard for people to hack into my life. And you should be doing this too. And again, it's a simple mouse click, so you should be setting this up. Now, there's one thing I do recommend is when you set this up, you can also download and store some emergency backup codes. I highly recommend doing that. It makes it very difficult to reset otherwise, and that's the one caution I give you when it comes to two-factor authentication. Also, make sure that you're able to log a lot of the information that's happening. So here I can see when I was last active in certain accounts, and that enables me to check and make sure nobody's accessing my accounts on an irregular or unauthorized basis. And I also update my software frequently. So one of the great things about the mobile app environment is that it updates frequently. So as soon as any vulnerability becomes known, you can actually update quickly to it, and you're covered. And it also creates backups for you. So by using mobile services, you're actually less likely to be susceptible to things like ransomware attacks, because you can always roll back the clock and have your files from a third-party location. So what app should you be using to get these benefits and to force these mobile steps? Well, there are tons of articles out there. You can swing by the Clio blog for our 21 best apps that we have chosen. But I think they come in categories. I think they come in categories of communication, task and calendars, data access, documents, time and billing, and then legal specific. So I'll just jump through some recommendations quickly so we can go to your questions. So for communications, I think you should use something that allows for encrypted communication. So there are two examples of these that I want to provide. There's Clio Secure Messaging. You can see that on the left. That sends an encrypted message via a client portal to your clients. Or you could also use something like the Signal app. Now the Signal app is a great app. I highly recommend it, but it requires both parties, you and your client, to have the app. So you do have to kind of train them to download it. Now, what I like about this app is it uses end-to-end encryption. It allows for things like text messaging, sometimes voice and video communications. And we know for a fact that they are willing to fight on your behalf against accesses for information. So this is from October in 2016. They were served warrants and gag orders from the FBI, which they successfully fought with the help of the ACLU and the Electronic Frontier Foundation. Now, as part of that, they did have to turn over some information. And this is literally what they turned over. They weren't able to turn over anything other than, yes, this account exists. Yes, this is the last time we connected to it. They do not store any records on the messages that you send, making it very difficult for somebody to access and demand access to those records. So I highly recommend Signal. I think everybody should be using it. If you're looking for something in a legal specific category, I also recommend Clio because it doesn't require your clients to download and store any additional apps. You also need something for task and calendars. Now, most mobile devices come with something built in automatically. I want to recommend that you do not limit yourself to free versions of that software. So if you're going to be using the Google Calendar that's built in on your Android phone, make sure you link it to a paid G Suite account. It has a stronger privacy policy, a stronger terms of service, and is much more likely to protect your interest and the interest of your client in storing information on that calendar. I want to give you a sneak peek right now here of the Clio calendar, where we have actually started building in machine learning, where it recognizes important tasks and activities for you and starts making those available in an organized fashion. So for example, you can take a look at your task management and see your to-do, but also it starts breaking it down, right? What do I have due today? What do I have due in the next 7 days? So I can really look forward and get an idea of how to work my day based upon the task and calendar that is at hand. And that includes being able to filter information and organize it. You can even provide time estimates and track your time along the way and turn those tasks into a time entry, and we'll cover that in time and billing. But it's all about having a good calendar that enables you to meet your deadlines. Now, you also want data access. It's not enough just to have access to your calendar, your task, and your communications. You're definitely going to have access to the information stored within your case files. And we know that Dropbox is the most popular app used by attorneys to store this. I also highly recommend Box, which is another great one that has, I think, a stronger emphasis on professional tools and is very helpful to you then, including things like providing business associates agreements for those of you who have HIPAA concerns, for example, but both are very good services. Now, most of what you're going to be accessing as part of those are documents. And so I recommend picking a document suite that has mobile apps. There is Google Suite, and there's also Microsoft Office 365. I am leaning much more heavily in favor these days of Office 365. Now, it requires you to have a pro plan. It's about $9 a month, but their iPad apps are just amazing and work incredibly well. And what's interesting is you can actually take both of these, either G Suite or Microsoft Office 365, and integrate them not just into your mobile device, but also into your practice management software. They both sync with Clio. So any changes I make to a document on my iPad and I save to Microsoft Office's OneDrive will immediately show up as a changed document in my Clio account. And it's that type of integration that you should be looking for. I also think when it comes to PDFs, you should definitely take a look at the popular tools amongst lawyers, GoodReader or iAnnotate, which are great for handling and redlining through PDF documents, and I use them all the time. You should also be able to track time and billing. Remember, less than 10% of lawyers track time via their mobile device, even though you're using your mobile device regularly outside of the office. That's ridiculous. You should be able to start a timer. So here's an example of a Clio timer, but there's other great tools out there like Harvest that work very well in terms of tracking time. The good news about using something like Clio is it actually plugs that time into your billing system as opposed to a third-party tool like Harvest, but there are lots of good tools out there, and you should definitely build those into your mobile workspace. Now, legal specific, these are the last apps I'm going to recommend, but highly important that you have something that works for your type of practice. If you're doing legal research, take a look at Fastcase. They're mobile apps, and the mobile research done on them are free, and that makes it the most popular legal specific app out there. So it's good for both Android and iPhones and works great. Now the last two I'm going to focus on are mostly iOS, so iPad devices. There's Agile Law and TrialPad. Now both handle different types of documents. So Agile Law is a deposition tool that enables you to control your document presentation for depositions, including highlighting of passages, taking notes, all from paired iPads. So I can put an iPad in front of the deponent, show them different types of documents and evidence, and have their comments on it, and I can control their view from my iPad. And TrialPad by Lit Software does the same thing, but it's evidence presentation as a part of trial. So it's a great way for you to have your exhibits all lined up and project them, say, onto a big screen quickly and easily. So if you have all of these categories of tools, so communications, task and calendars, data access, document editing, time and billing, and legal specific, and they all flow together as part of a mobile package, they'll actually work really well as part of your total law firm software package as well.